Today's webinar. My name is Laura and I will be your session organizer. Before I introduce our presenters for today's session, I have a few housekeeping items that I'd like to bring to the audience's attention. On your screen are multiple application engagement tools that you can use. All of the engagement tools are resizable and movable. Before I introduce our presenters for today's session, I have a few housekeeping items that sorry about that. All of the engagement tools are resizable and movable, so feel free to move them around and get the most out of your desktop space. If you have any questions during the webcast, you can submit them through the Q&A box. Questions for our speakers can be submitted in the Q&A box at the bottom of your screen. Our presenters will do their best to answer your questions when appropriate, but plan to have a devoted Q&A portion at the end of the panel. For the best viewing experience, we recommend closing any programs or browser sessions running in the background that could cause issues. Webinars are bandwidth intensive, so closing any unnecessary browser tabs will help conserve your bandwidth. If you have any issues with slides or audio, please refresh your page. An on-demand version of the webcast will be available approximately 24 hours after the webcast and can be accessed using the same link that was sent to you earlier today. Following the session, our brief post-session survey will become available on your screen. We appreciate your feedback as we continue to improve our programming for law students and all of FBA's virtual offerings. Now I'd like to turn the mic over to our moderator for today's webinar, Eric Foley.
Thank you, Laura, and welcome everyone to this webinar. I'm really excited about today's webinar today because we have 4 civil rights practitioners who not only are doing really exciting work, but really demonstrate the kind of breadth of civil rights practice, and also that there are many different ways to get to civil rights practice and different ways to be a civil rights lawyer. Normally, you know, there's long introductions of panelists in these things. I'm going to do pretty short introductions because so much of this webinar is going to be talking about people's career paths and CVs. So I'm going to introduce folks really quickly, and then we're going to jump straight in. We're going to reserve some time at the end for questions, and they'll also be, you know, monitoring the questions in the Q&A box. I've got some questions I'm going to ask the entire panel, and then we're going to ask some individual questions to folks, and then we'll round up with the audience questions at the end. So without further ado, let's tell you who's actually on the panel today. I'm not going to just regurgitate the panel bio, so I'll go quickly. First up, we have Elizabeth Barton. She is Assistant Deputy General Counsel for the Chicago Public Schools, which is the 3rd largest school district in the nation. And she manages federal litigation for the Chicago Public Schools. There are 355,000 students and something like 60,000 employees, if Wikipedia is correct. And that's an anxiety-inducing number of folks and number of potential legal matters that would arise. So Elizabeth has some wide experience, and I think will be an invaluable member of this panel. Next up, we have Kashana Hill, who is the Executive Director of the Louisiana Fair Housing Action Center and does amazing work in Louisiana on housing rights, and is one of the leading civil rights attorneys in Louisiana, and one of the youngest directors of civil rights litigation organizations in Louisiana. Next up, we have Wiley Stecklow, who is a solo practitioner and has been a noted civil rights litigator for many years, and particularly was involved as an advocate for Occupy Wall Street, and has some really great and interesting experiences there, but has also done a ton of other cases that kind of run the gamut of civil rights practice. And then lastly, we have Jonathan Chanel from Disability Rights Louisiana, and I have to always correct myself because I want to say the old name of that organization, which I'm so familiar with. Jonathan does really cool work on conditions of confinement and particularly solitary confinement. And for some of that work, he was awarded the 2019 Advocacy Award by the Disability Rights Network, and is a brilliant and really innovative attorney. And has, again, a wide experience like all the panelists here. I think one of the advantages of today's panel is all these folks have done a lot of different work in the legal field. And so they'll have great perspectives to bring to you. So without further ado, I'm going to jump in with some general questions here. And I'm going to start with Liz and ask, when you were like a 2L or 3L and getting ready to graduate law school, what did you think your career path would look like? And then what has it actually entailed, and how did it differ?
Thanks. Good question. So I graduated from law school in 2008, which was a particularly difficult time for people to find jobs. So a lot of us were really struggling with finding work. And I originally went to law school because I wanted to be an employment lawyer. My background, my undergraduate degree is in business management. So I really gravitated toward my employment law courses, sort of in the HR area. And so I really wanted to do employment law and wanted to actually be where I am right now, but it took a little bit of time to get there. So in 2008, it was really, like I said, it was really difficult to get a job. Not a lot of firms were doing on-campus interviewing. Not a lot of firms were making offers to their summer associates. So I really had to start getting creative about how I was going to find a job. So I was a teaching assistant for one of my professors, and she actually sat me down and said, "Liz, I think you're a great student. You have a lot to offer. I can't believe you don't have a job. How can I help you?" And so she just kind of sat me down and talked, and I talked to her about what I was interested in and what I might want to do. And she put me in contact with a couple of her her former students. And I just went out and met with them and talked to them about their career paths, how they got to where they are. And one of them actually ended up offering me a job as a clerk. It was in the suburbs of Chicago, and the law firm was a very small law firm. So it was not the ideal for me of what I envisioned myself, working in downtown Chicago and the Chicago Loop and working at a big firm and doing really interesting things. And so I really had to think about, is this something that I want, to be in the suburbs at a small firm that only had maybe 5 or 6 attorneys and make that commute out to the suburbs every day. But I took the chance, and it ended up really benefiting me. I learned a ton. I loved working at a small firm because they really had to kind of throw me in. So I started out as a clerk, and then I studied for the bar exam and passed the bar. And then I started working for them, and we did really interesting work and should I run through kind of my career trajectory yet or no?
Yeah.
Okay. So I worked there for about 5 years, and the work we did there was civil rights. It was some employment law, which is why I was excited to work there. But primarily we were doing reverse conviction cases. Some people know them as wrongful conviction cases, but I'm a defense attorney, and so we refer to them as reverse convictions because the feeling being, even though a conviction was overturned, doesn't mean it was always wrongful. And so I was representing police officers, prosecutors, counties, different municipal entities in reverse conviction cases, which was really interesting. They were large litigation cases with dozens of depositions and hundreds of thousands of documents, dozens and dozens of witnesses. So it was a lot of really great work because there just wasn't enough attorneys to really get it done. And so I got a lot of really great experience. In doing one of the reverse conviction cases, I was co-counsel with my future boss, who poached me after we spent maybe 40 or 50 depositions together, where I would ask, majority of the questions and kind of do I had the laboring oar, I would say, for the depositions on that reverse conviction case in particular. And my future boss was my co-counsel, and he was much more experienced than I was. So he would kind of come in at the end of the deposition and ask those really wonderful questions that were going to help us tie up our defense. So he ended up offering me a position because he worked at a firm in the city in Chicago. And I had just had a child, and so I really didn't want to spend all that time in commuting any longer. So I ended up accepting a job with him, and that was at a mid-sized firm. And I spent another 5 years at that firm. We were doing all different types of municipal litigation. So I was representing school districts, park districts, cities, townships, any kind of municipal entity that found themselves in trouble. A lot of my work had to do with police misconduct again, because that was my area of expertise, but it really expanded from there, and I was practicing all different types of municipal litigation. I took a job at a larger firm after another 5 years there. So I went to a large firm that had offices in many different states. But I ended up doing insurance coverage law, and I really disliked that. So I only lasted there for about a year until I found this position at the Board of Ed. So currently I work in the law department for the Chicago Board of Education, which oversees Chicago Public Schools. Eric, your statistics are correct. We have over 350,000 students. We have about 40,000 employees. We have like 650 schools. So it's a busy practice. Our law department is not very big. We're one of the largest, I think we're the second largest employer in the state of Illinois. Second only to the federal government. So we have a lot of employees and a lot of things going on. But I manage the federal litigation team, like Eric said. So the types of cases that we see typically involve employment disputes, which of course is my passion. But also we have constitutional claims, a lot of constitutional claims under due process, First Amendment, Fourth Amendment, if we have police officers in our schools, if we have teachers or dean of discipline who may have engaged in some kind of use of force or corporal punishment with students, we see Fourth Amendment claims. So we handle those as well. We also have Title IX claims under, and those typically are the like sexual abuse type claims. So those are filed usually under Title IX. And we give a lot of guidance to our clients, to our client types. We give guidance to principals, to other lawyers in the law department who might be issuing labor and discipline, or things that might turn into litigation. We review policies. So it's a really wide range of work, and I really enjoy being in the public sector. This is my first public sector job, so I'm no longer billing hours, which is really nice. And I love that in particular, which is good for being a mom. But also it's just a really wide variety of work. And I feel like it's an important work. It's a really easy mission to get behind public education, in my opinion. And we can always fall back on, which is a trial attorney's favorite thing. You can always fall back on, this is about kids, this is about their safety, this is about their education, so that's always easy to justify our decision making at the board. So that's a little bit about me. Thank you.
Thank you, Liz. As you were saying that, I was thinking of Reverend Lovejoy's wife. Won't somebody think of the children? It's
like the easiest mission to get behind. Convince the jury to get behind, too.
So I'm going to move along in alphabetical order and pose the same question to Kashana and ask, when you were a law student, did you think you were going to be the director of a housing rights organization? And is this the way you thought you would get there? And if not, was there another way you thought it was going to happen?
Yes, I did think I was going to do this. Thank you, Eric. And I can expand on that a little bit. So I went to law school right after college. I attended Spelman College, which is a historically Black institution for women in Atlanta. And I knew, I would say before I even went to college, that I wanted to be a civil rights lawyer. What that meant, I wasn't sure how I wanted that to look. I wasn't sure, but, my experiences as a young Black woman growing up first in Portland, Oregon, which is my hometown, and then in the northern, very white, very wealthy, politically conservative suburbs of Atlanta, really led me to decide that this was the track that I wanted to go on, and I wanted to work in communities that were experiencing oppression. And so in law school, I really sort of took the time to figure out how that would look. And I would say that, I went to law school without any expectations of how my experience would go. I've always been a really voracious reader. I've been reading since I was 3 years old, had read, lots of books. When I went to law school in 2002, there were lots of people talking about The Paper Chase or something, which I still have never read. But I didn't have any expectations of what law school or law practice would look like. I read all the John Grisham novels up to that point, and that was kind of the exposure that I had to lawyers in law school. I didn't come from a family or a background where we knew attorneys or things like that. So I remember being in law school, not even knowing what law review was, right? So I didn't have this idea I'm going to come into law school and be on law review and get these grades and go work at a firm. All of that was the furthest thing from my mind. I remember my classmates doing the on-campus interview process, and it was very clear to me I would say the moment I stepped foot into law school, that the legal education system was not set up to support public interest careers and careers in civil rights. And I actually still stand strongly by that. I know that many law schools have developed, cutting edge programs and supports for students who are interested in public interest law and in careers in civil rights. But I would say as a whole, generally speaking, even though it's been 15 years since I graduated from law school, the legal education system in America is set up to sort of drive students into careers in big law, right? And with law firms. We've just not, as a community, gotten creative about how to support law students who aren't interested in those kinds of jobs. Of course, nothing wrong with those kinds of jobs and that kind of work, but it wasn't what I wanted to do. So it was clear to me from the beginning that I was going to have to make my own path. And that's actually something that I share with students that I come across. I always want students to know that if you're interested in a public interest career, you may have to figure out a way to do it on your own and figure out the kinds of supports that you need. And so that's what I did. I just put my head down and figured it out. I didn't clerk at any law firms the whole time I was in law school. I worked, actually my first year I studied abroad, and then my second year I clerked with the managing attorney of a domestic violence unit at the local legal aid office that, Eric, I know you're familiar with. So I was able to get that courtroom experience and that client advocacy experience throughout my second year of law school. And then, my third year I was a member of the Civil Rights Clinic at Tulane. So I really went out of my way to sort of figure out how my career would look. When I graduated from law school, I moved back to Portland, Oregon, and was practicing there for about 6 years before I came back to Louisiana. And I had a variety of jobs. I clerked for a judge first at state trial court. I wanted to get a chance to see trial practice up close, and then also to get a chance to introduce myself to members of the legal community in Portland, because I hadn't gone to school there and hadn't lived there since I was a child. And so I needed to build my network from the ground up because, again, didn't know any attorneys. So I did that for 2 years and actually was offered a position with a very small insurance defense firm. And for the students, I'm just going to take a moment to explain what that means. I was working for a law firm that was hired by insurance companies, and we actually did construction defect litigation, which means that, if a homeowner sued the builder of their house because there was a problem with the way the house was built, then we would represent the builder or maybe the person who did the roof or the windows or something. And so I did that work for about a year and a half. And the reason I took the job was because the owner of the firm, there was just one partner. He was running what was really, I thought, a pretty innovative practice that would provide some great learning experience. So, 4 weeks after my first day in court arguing a motion that I had written. I have many friends that worked at large firms and they didn't get to do their first deposition until they had been practicing at a big firm for 8 years or 10 years or something like that. And I wasn't interested in that kind of experience. And so I went to work at a law firm that was very small, where we were responsible for our work product. And I learned in a year and a half, and then left to go to the local statewide legal aid organization where I was representing low-income victims of housing discrimination across the state. I left and then came back to New Orleans because I had been recruited to work at the Fair Housing Action Center. So I joined that staff as an attorney. And then about 2 years into that role, I was asked by the new city attorney in New Orleans to come and join her law department. So I actually went over to the city attorney's office and worked there for another 2 years until I came back to the Fair Housing Action Center as executive director. So the work that I do now doesn't really involve practicing law, so to speak. But, you know, fair housing litigation is definitely my passion, and it's what I've thus far, you know, dedicated my career to. So I'm probably a little more engaged than the attorneys on my staff would like for me to be because I just can't, you know, fully get out of the casework. But the organization that I run is focused on challenging discriminatory housing policies and practices through litigation and policy advocacy and education and outreach efforts. So I really appreciate the chance to, you know, be holistically involved in ending housing discrimination and segregation, and then also working in communities that have experienced and know firsthand the harmful effects of residential segregation.
Thank you, Kishana. I think between you and Liz, one theme that's sort of emerging here is flexibility and openness to experiences. You guys have such varied work experience. It's great. I was going to turn next to Wiley and ask the same question. And particularly, I know a lot of people are really interested in how does one even become a solo practitioner? How do you hang out your own shingle? I think for a lot of people, it's sort of a terrifying prospect. And so I hope you can tell us a little bit about how you got where you are today, Wiley.
Sure. Thanks so much, Eric. And it's great to see Kishana back here, and it's nice to meet some new folks. So my name is Wiley Steffel. I am a civil rights attorney. I've been doing that for a couple decades now. You know, when I graduated law school, I went to Big Law. I got a couple years experience doing that. Then I went to work for a medium-sized boutique litigation firm for a year or two, and then to a small criminal defense firm, and learned criminal practice, learned really how to run a small practice. And that's after that, I was 5 years out of law school. I started my own practice. I hung out my own shingle. And I started by doing what's called 18B work in New York, which is when legal aid is conflicted off of representing indigent defendants in criminal court. They have private lawyers come in. It's called 18B panel. And so I was certified to be on that. And that was helpful to pay my overhead while I was trying to build up my practice. But it took, you know, a few years to actually build it up and to get to the point where I no longer took the 18B work, where I was now making more money and helping more clients in private practice. I didn't really get into civil rights for a few years. I was doing some employment discrimination work and some negligence work, and even some insurance coverage dispute litigation that Liz spoke of a little bit about. But I was on the other side. I was on the plaintiff side of that. But I got referred to me an unlawful arrest case. And I looked into it and realized it was a mistake. And somebody had bizarrely used somebody else's identification, got arrested, used the identification during the arrest, and got put on probation, and then fled the jurisdiction. 2 years later, the guy whose wallet was stolen is in a car, is pulled over, and when they run his license, they see that he has a warrant for blowing off probation in New Jersey. And he then goes to jail for almost a year and a half because he didn't have good English skills. His lawyer didn't spend enough time to figure it out. And it took a while before somebody finally listened to him saying, I didn't do this, it wasn't me. And so I did that case. I really enjoyed it. I really felt like I found my calling at that time. And that was probably in the late 90s. In 2003, I joined something called the Billionaires for Bush, which was an ironic group. We were not actually supporting Bush, but we're going around in top hats and tuxedos and following his campaign around and talking about how this was the best president money could buy, and things like that. And I got much more into activism from that. I had been an activist growing up and had gotten away from it, and this brought me back into it and brought me into the activist community and brought me a lot more work as a civil rights lawyer. You know, both dealing with the police at protests and things like that, as well as dealing with unlawful arrest cases. And I'm not sure exactly how Liz or somebody else might term an unlawful arrest as opposed to a wrongful conviction. But that started to be stuff I saw all the time. And as an activist lawyer, I would be out in the streets helping people. I'd be getting phone calls from groups. We're about to do a protest. We have some questions. So I'd be speaking with them. I try to advise them. And you would learn about different jurisdictions and different situations and where the problems really lie, where the police dug their feet in and the district attorney's office may dig their feet in compared to where they might give out an easier disposition for the arrest. And from being the person who was helping them with the protest, when the arrest or the protest went awry and there'd be what I consider to be unlawful arrest happening, I would then be the lawyer going down, getting people out of jail, trying to fight the charges. And if I was successful in beating the charges for the clients, I would then have a civil claim. And I started to learn how to do civil rights litigation that way. So between that first referral case and getting into activism, it really helped me build up that part of my practice to where it overcame my practice. By 2011, when Occupy Wall Street occurred, it was all I was doing. I was doing 100% civil rights litigation. I had an associate who would come on to help me with some of this unlawful arrest cases. And once we got retained by the General Assembly of Occupy, I brought in 2 more lawyers. And we had now, I think, at one point, we're up to 5 lawyers in the small firm. And we're, it's an investment forward, right? We're not getting paid by the hour at the time that we're doing the work. So you have to be able to sustain the practice somehow so that you can get paid on the work you're doing now 2 or 3 years later. So there's a theory for the solo practitioners and small firm practice is you have a pipeline. And you have to have in that pipeline cases every step of the way, starting with cases in the beginning that you're just seeing and maybe you have intake meetings coming up, all the way through to cases that are settled already and you're waiting on the check. And as long as you have that pipeline full, and that's not going to be full your first year out, which is why I had the 18B panel to pay my overhead as a solo. But once you get that pipeline full, you can continue to take in new work when you know you're not going to be paid for a few years. Now comes COVID, and all things are out the window. Now the city of New York is claiming poverty. They're claiming they can't pay out in the cases that are at the end of the pipeline that we anticipated settling. We can't go to trial any longer, which was really the big hammer we held over the city. If you don't settle, we'll take the case to trial. Well, now the judges are telling us we can't do jury trials. Right? Not right now. We'll adjourn this till June. So we have a pretty big case suing the city for failure to train officers on the correct way of policing sidewalk protests. And we beat the motion to dismiss. We beat the summary judgment motion. We were getting trial ready. We were supposed to have an October trial date. And the city is refusing to come to the table to settle. But we thought with an October trial date, by September, we'd be having good conversations. But that trial date's now pushed off till June, with the judge saying, I'm not even sure June's a realistic concept. So it's a difficult time to be a civil rights lawyer. We're very busy. I'm doing a lot of work with the Floyd protest. The National Lawyers Guild in New York has started the NLG Floyd Affirmative Litigation Task Force, of which I'm on. And so there's a hotline, and people are calling in all the time. We got arrested. We have questions, and we're answering these questions. We're signing up cases. We have new cases to move forward on. We don't have the end of the pipeline hanging out. So it's a difficulty at times, and it's not always simple and easy. But it's a calling, and it's something that I really enjoy. I always feel like I'm waking up. I'm on the right side of the V. I get to wear, I get to be the hero in a lot of people's stories that they come back. I was just, while we were prepping for this, I took a minute to return a client's phone call to explain that the city is not doing summons cases now, so her protest arrest won't be coming up October 2nd like she thought. And I told her I was doing this panel. She goes, tell the students we need them. We need more civil rights lawyers. We need these types of lawyers out there. So that's sort of my background. And I just want to make one more comment, which is the one thing I missed out on as a young lawyer that I would do if I was a law student, I was to do it all over again. I really like my career path. I really like the trajectory. I like to where I've ended up. I really have enjoyed my practice. What I didn't do, and I really wish I had, is a clerkship. I know Kashana had said she had done a clerkship. If I had the opportunity to do it again, I would have been applying to clerkships out of law school. I would have tried to get a federal clerkship, and if not a federal one, anyone I could have gotten my hands on. I think that is invaluable experience and something that will only help you down the road.
Thank you, Wiley. That was really helpful to hear, like the actual, I've never heard anyone actually tell people the real logistics of being a solo civil rights practitioner so well. So thank you. Jonathan, so, similar question to you. And how did you see your career path going when you graduated or when you were a young attorney? And how is, not that you're not young now, I mean, you're certainly young, Jonathan, but now, as opposed to where you are now, and what are the differences?
Okay. So way back, and this is a similar answer to the one from Ms. Martin earlier, I graduated in 2011, which was not quite as bad as 2008. The financial crisis had settled down a little bit, but the market for legal services was still bad. At the time that I graduated, I was actually most interested in environmental law. And I had, done a lot of classes about environmental law. I hadn't really thought very much, actually, about doing any kind of civil rights law. The first job I ended up taking out of law school was actually a research fellowship, working for one of my professors, doing some just summarizing proceedings at the California Public Utilities Commission. And then after that fellowship ended, I went to work at the Public Utilities Commission doing investigations into fraud by the utilities against the customers. It was not our job to care if a customer pulled one over on the utility. Good on you if you did. We were only interested in the other way around, where utilities were using their positions of authority basically against their own customers. And the things that actually made me a good fit for that job, it didn't turn out to be law school stuff. It turned out to be that when I was in college, I was a linguistics major, and I knew how some of the audio processing software worked. And what I said was, I can look at these recordings, shove them through a piece of software that I understand, and if it looks like they've actually stitched together the person's responses to commit fraud against that customer and change their services, we could just bring a case on it. And it turned out that that was actually the thing that got me the job, not great grades in law school or something like that. So I spent a few years doing that. And then the California Public Utilities Commission encountered some internal troubles, wherein one of the commissioners was caught essentially accepting bribes in order to select the judge who would hear particular cases, in order to advantage some of the utilities who appear before the commission, at which time the work of the Safety and Enforcement Division slowed substantially out of concern that we were putting cases then in front of a contaminated commission. And in that time, a friend of mine who happened to live down in Louisiana had an opening at her job. And at that time, in what in retrospect is a giant failure of imagination, I thought that it would be important to fight against Bobby Jindal's vision of privatization of all government functions to the point of anarcho-capitalism as one of the big threats to America at the time. Now it is very 2015 thinking, and looking back on it, it's not quite how things shook out, but essentially there was an opportunity, and I jumped at it. And that opportunity was to push for actual Medicare and Medicaid for people in the state of Louisiana, and to make sure that students in Louisiana were actually getting special education services, and that people with disabilities in Louisiana weren't being discriminated against on the basis of their disability, receiving their appropriate reasonable accommodations. It just, to me at the time, looked like, well, yeah, this is great. It's work of conscience, and it's helping the underdog. So I was very excited to make that transition, and I did, and I started, to work some more systemic cases and to try to get involved in addressing some of the root causes of the issues Louisiana was experiencing at the time, and for much of the state still is. But progress comes slow. And it was sort of without realizing it that I kind of picked up the label of civil rights attorney. And it was in doing that work, and just being open to new experiences that I sort of landed in my current role. I definitely, did not have any real background in prisoners' rights litigation to speak of at all. But Disability Rights Louisiana is an organization that's called a protection and advocacy group. And those protection and advocacy groups are empowered by the federal government to conduct certain kinds of investigations. And to, appear, you can look at basically anywhere where people with disabilities are housed, employed, educated. It exists as a stopgap to make sure that people with disabilities are not stockpiled in snake pits, which is a problem that occurs more often and even more recently than people would like to think. And I, just on sort of a lark, had taken over one of those investigations from a friend of mine who also worked there. It was actually the same person who initially recommended the job to me. And when I went there, to this prison, I ended up going on to their solitary confinement tier. Under our federal authority, we're allowed to do that. And at that point, the career trajectory went jackknifing off into a brand new direction. That what I saw and heard and smelled terrified and enraged me to my core. My position at the time was not imagined as prison litigation attorney. The things that we were there looking at were essentially just minor issues around quality of mental health care and, some pretty alarming reports that had come in, but we hadn't really understood the gravity of what we were dealing with. And essentially, when I came back, I did my level best to put the organization on the war path. And within a few weeks, we were back in federal court and pushing for some changes to that facility, and basically haven't stopped with that since. So I think, we're definitely right that there's some themes that have appeared and been consistent throughout all of this. And I think if I had any one piece of advice that sort of ties all of this together, it is to be open to new work where you feel like you might learn anything, or that you feel like it might be interesting in any capacity, even if it's not something that you imagine yourself doing for the very long term. Even just spending time doing work that is unfamiliar to you and widening your horizons. At a minimum, you come out of it a more well-rounded and broadly experienced person. But it is also possible that it can lead to realizations about who you are and the world you live in that can have profound and long-lasting impact on your life and your career. So, I think that's my answer to the how do you track too well to present.
Thanks, Jonathan. I'm going to move forward and ask a couple relatively rapid-fire questions to y'all, and then I'm going to pose some sort of more individualized questions to you. But one thing I wanted to ask was, I remember being a law student and thinking that, how easy is it to move from the defense to the plaintiff side and back and in practice, and how difficult is it? Is there a litmus test, or do people view you differently if you've worked on one side and try to go to the other? And so I was wondering if any of y'all might be able to address that, because it sounds like several of you have that sort of experience.
Let me jump in here, because I've always been a defense attorney, but I just hired a new senior assistant general counsel who is one of my supervisors on my team below me, and she has been practicing as a plaintiff's employment lawyer for 12 years, and she's made the switch to come over to the defense side. And so we asked a lot of questions of her about why she wanted to make the switch and, what challenges she thought she would face being on the defense side. But she's honestly been really wonderful. And one of the greatest things that she's experienced being at the Board of Education now is that she feels like she's still doing good work because she's helping to work on the root causes of some of these potential discrimination, harassment, retaliation even begins. And so she's working on considerations, the client to take some preventative steps before it might turn into litigation. And so she's found that particularly rewarding coming from the plaintiff side and to the defense side, where she feels like she can actually make a difference on a bigger scale to just one individual plaintiff. So I just would like to share that.
I'd like to add something as well. I think that was an interesting point from Liz, that although I've always been, as a civil rights lawyer, on the plaintiff side of the V, and I do some commercial litigation and other things on the other side sometimes, a lot of the other civil rights lawyers in New York, some of the very good civil rights lawyers in New York, were originally corp counsel at the New York City Law Department. And that's not an unusual trajectory for a career path, to work as an assistant corp counsel, get some great trial experience defending these cases, make friends with a lot of the civil rights bar, and then switch to the other side of the V. So I don't see it going the other direction, as Liz just explained it has in her experience. But from what we see in New York, there's a lot of people going from getting into the industry by going to work for the city, getting experience, getting trial experience, which is very difficult to get and very valuable, and then coming out and being among the best civil rights lawyers we have here in New York.
I would also just like to come at this from a slightly different perspective, because Disability Rights Louisiana is in a little bit of a different position, because we aren't sort of a general civil rights practice. We are often some of the experts in a very specific or tiny and technical area of law, like the state's Medicaid program, for example. Like, a lot of the people who know the most about it are in our office, and so very often people who are leaving our office go out to the Medicaid program, or because of the experience that people have with the disability discrimination cases, they go on to take other, compliance jobs, like with schools or universities. So some of that might be because of the particularities of how the Louisiana legal services market works and its relatively small size. But I think it's also important to keep in mind that these answers might change a lot depending on not just which side of the V you're on, but what specific subset of civil rights law you're practicing. Because it's possible that if you're one of the very few experts on something, that you might end up getting plucked to or from either side of the V if it's a small practice area.
Great, thank you guys. I'm going to switch it up a bit and go to one of the audience questions on the theory you got to give the people what they want. And I think there was a good question by Joey Brown, who asked, it referenced Brian Stevenson discussed the importance of proximity to the poor, marginalized, and underprivileged communities we hope to serve. As a 1L, it already seems challenging to balance the academic and arguably privileged experience of law school with the social justice work I hope to eventually do. And what advice would you give for finding that balance and keeping that proximity? And I think that's a great question. And I was going to ask a similar question of Wiley about, the kind of the mechanics of being a movement lawyer. And but I want to open that up to everyone on the panel to respond if they have any thoughts on Joey's question.
If I could just take that, I really love that question and appreciated it. So thank you, Joey. And I would say for me, what I didn't have to find a balance. I mean, I come from the communities that I serve, right? And so it was doing things this way was really my only option. And so in the law school space, the jobs that I had served these communities, right? So when I was clerking with the legal services office, that's what we were doing, serving people who, meet the federal poverty guidelines, and also with the Civil Rights Clinic at Tulane Law School, we also had those income guidelines as well. So we were serving people who had experienced, major difficulties, either as survivors of domestic violence or folks who had their civil rights violated. And so, the populations that were served were these folks who are poor, who experience oppression. And I sought out work in that space. I think there's a lot of ways to do it, right? Whether it's volunteering, even, through who you are and the way that you share your experiences with community, that's possible. But I would just say that I absolutely agree that keeping proximity to those folks and those groups is imperative. If you want to work as a plaintiff's civil rights lawyer, that is certainly something that I look for in people that I hire at the Fair Housing Action Center. And, I would say, Joey, you kind of have to figure out how to do it. And I know that if it's important to you, or for any of those students that this is important to, you will absolutely figure it out.
I'll add to Kashana's comments. I think that they're spot on for the experience that she's had, and for people who are going to have that similar experience. Obviously, that wasn't my experience. I didn't grow up in that type of neighborhood, and that's just the reality. Like I'm not going to apologize for it, but it's my reality. It's my background. It's my experience. But the way that I try to stay connected to the community that I serve and to these individuals, and I'm one of the lawyers that started a Thursday night legal night in Harlem. And so the last Thursday of every month for about 10 years now, we would go up to National Action Network's House of Justice up on 145th Street in Harlem, and we would have a 3-hour conference with the community. Anybody can come there, and they could come there and ask us questions, and they would get to speak to a lawyer either by asking during the Q&A or a one-on-one afterwards. And oftentimes that helped them connect to lawyers. And it was very rare that I would actually get a client from that turned out to be something profitable, but it was always worthwhile, right? There's a difference between revenue and worthwhile work. And so I found that to be really, really helpful. I'll also say that I've worked the last few years through the Federal Bar Association's mentorship program and the Second Circuit Justice for All program. I've done some mentoring where I've gone into high schools, and I've chosen the high schools to go into are ones where the students have had difficulties getting through their education. And so I feel like I'm dealing, and they're also in specific communities and in specific areas of Manhattan or outside outer boroughs. And I'm dealing with students who are not at the age or the credits where they would be to graduate on time because they've run into some difficulties. And I'm going in there and I'm speaking to them about knowing their rights, how to deal with police, how to try to avoid getting a criminal record. And then I'm working with them to bring them to the courthouses. And I do a program that's twofold, one in the school, and then we go and we do a field trip to the Eastern or Southern District of New York courthouse to meet with judges. And that helps get them into some contact in a way they wouldn't otherwise do it. And also, I found it to be really interesting that they can then be told during this program what some of the other jobs other than lawyering is at these courthouses. We have other people from their community who may be working there who would come and speak with them and tell them about their job and their trajectory and how they had their career within the judiciary system that's not as a judge or a lawyer, as well as the chief judge of the Eastern District, the last time we did this, happened to have grown up in the same housing as some of the students. So it was a really amazing moment for that connection to be made. So that's one of the ways I try to continue even now, connect with certain communities and keep working with them, even though I don't believe it's one that leads to revenue work. I don't think that's always what's most important as a civil rights lawyer.
Thank you, Wiley and Kashana. We have some more questions from the audience. Before we hit those, I wanted to check in quickly with Liz because there was a question I wanted to ask all of y'all, and anticipated it, but I didn't get to hear from Liz, which is kind of this idea of like, if you were able to go back and advise yourself as a law student or a young lawyer about either a mistake to avoid or something you wish you should have done that would have helped you get to where you are today, particularly with government practice and having the breadth of subject matter that you have to deal with, what might that be?
So I think as a young lawyer, one of the most difficult things that I faced, especially in the work that I was doing, was representing police officers and people who did not trust lawyers and who certainly didn't trust young women lawyers. So that was really difficult. And so I developed a big skill set on how to communicate and get my clients to trust me. But one of the things that I wish I would have known, I think, is something that I learned later, and it's something that I pass along to. I teach law school too, so I teach my law students this: is no matter what area you go into in law, and no matter how much you think like you're fighting the good fight and you're representing these clients, and it's really something that you believe in, there's always going to be at least one client or one case that you don't feel 100% about. At least that's been my experience. And so what I was taught is that in litigation, you really have to look at, is this in this, speaking from the defense side, I don't ever approach a case thinking, am I on the right side of things? Approach the case thinking, is this a defensible case or not? If it's defensible, then we defend the case. If it's not, then we reach a reasonable resolution for our clients. And I think that really helped me get through some of the more difficult cases that I faced. I certainly believe in my work, passionate about my work, but there are times where I get, especially, even now at CPS, where it's like, how could this teacher do this thing, right? Or how could this security officer do this thing to a child? It's awful to see that. And so I have to look at these with the lens of a litigator. Is this case defensible? And if it's not, then we really have to find a way to resolve the issue that's in a way that's respectful to the plaintiff, to the person aggrieved, and to the person and to the entity itself. So that was something that I wish I would have known earlier in my career as I struggled through getting to know, these police officers and their work, but thinking more of a lens as a litigator as opposed to, whether morally I was on the right side of each and every case. Because for the most part, I think I am, but there are always going to be at least one client or one case that just doesn't sit well with you, or your client's not telling you the truth, or they're not telling you the whole truth, or they don't tell you the truth until 2 years into the litigation or something. So there's always going to be those instances that come up. So trying to keep the litigator hat on is something that I had to learn how to do as a young lawyer.
This is Kashana. If I could just follow up on that, and I'm going to answer an audience question while I talk, if that's okay. So I want to tie in some of what I heard Liz say with the question from Martina at the Northern Kentucky University Salmon P. Chase College of Law, which is the question is around how to avoid burnout, right, and stress. And, I would say, again, as a Black woman doing this work and just living in America, right, when there's so much like dehumanizing of us and devaluing of the contributions that Black Americans, Indigenous folks, Latinx folks that we bring to this country and this community. And there are so many people emboldened, right, to say and do really awful things. One of the things that actually keeps me going and that helps me to sort of not get burned out or, stressed out very often is actually being on the right side of things. So I get to have, and I don't want to sound like, naive, and I'm not, but I get to have the luxury of doing work that I deeply and truly believe in. And I get to know that I am seeking justice, not just for individual clients. We certainly do individual cases as well. And I actually am of the mindset that any case brought on behalf of an individual does have a large community impact, because I've never worked on a case for an individual that only impacted that one individual, right? If you're representing someone whose landlord is sexually harassing them, they're not only sexually harassing just that tenant. And so if I get a bad landlord out of the game, then I've also been able to do something and be a part of something that positively impacts everybody who lives in one of that landlord's properties, right? And so I would say that there is a right and wrong in some of the work that is out there in some civil rights cases and in the universe. And so the work that I do, I get to feel like, and I get to know that I'm a part of seeking justice for our community, and that, we are taking steps to ensure that bad actors are held accountable. And so that's what helps me, is knowing that I'm on the right side, we're doing the right thing. But I just want to say, in response to Martina's question, that it can be very difficult. This work can be very emotionally taxing. And I think for everybody who has that concern about how they'll deal with the emotional aspect to all of this, I would say to you that if you are a member of a marginalized group, you're still here, so you've already been dealing with it, right? And you just keep doing that. And then in those moments when things are difficult, and I certainly had one of those days this week when we found out what was going to happen or not happen with the officers who killed Breonna Taylor, right? I had to take a moment, so I went for a long bike ride and make sure I did some yoga. And I also drank some wine. And we have to have our coping tips and mechanisms and do what we need to do in order to be able to continue to show up for our communities.
I really agree with that, and I want to echo a lot of it. Definitely interacting with people who are in solitary confinement and suffering from sometimes extreme forms of mental illness, it results in content that simply will be traumatizing. And sometimes if you take particular kinds of cases, you do have to accept that the content you will be dealing with is traumatizing. And there is no smart way around it. You cannot outsmart it. You are not immune to it. And it will add up over time. And the important thing is that you focus on coping, and you focus on making sure you have a team with a culture that is looking out for one another and creating space for people to preserve their mental health and their ability to continue to participate in that litigation. There are no gloves you can put on that will make interviewing somebody who is experiencing a psychotic breakdown in solitary confinement tolerable. That's not going to be an okay thing for you to even know occurred. And you have to be able to give yourself the time and the space to process those emotions and to make sure that you continue to remain effective in your work. But the honest answer is you have to create space. You have to do other things. You have to make sure that you have a team that's looking out for each other, because it is real and it is part of the work. And people who pretend as though they are immune to it are the ones who you have to be the most worried are going to be the bad burnout cases.
Yeah, I totally agree with that, Jonathan. Thank you.
Yeah, I can add on a little bit to what Kishana and Jonathan had just said, in that, and I think that they both have the experiences of the work they're doing and their background, which is completely different from mine. So I believe that their experience is a little bit more specific to the question. I just want to say that I had one of the 5 lawyers that was working with me during the Occupy situation, when I grown my firm to 5 lawyers, ended up leaving the law. And he said he couldn't deal with the stress. And so my feeling is you can't insulate yourself. As Jonathan's saying, you can't. It's there. It's part of the practice. It's part of what you're doing. You're going to be emotionally connected to your clients at times. You're going to be emotionally connected to their cases, and the results are going to affect you. And that's just something to understand going in with your eyes open and doing your best. As both Kishana and Jonathan said, they have their own ways of coping, whether it's with a team or a bike ride or a glass of wine or, maybe, a good po' boy if you can find one. But, there's definitely issues that will come from this type of work. And I think it'll come from almost any type of legal work. You're going to get caught up in it. So it's not necessarily just to this. But I think that for the type of work that Jonathan was just describing, it's clearly magnified and it's clearly a much bigger concern than it would be for some others.
All right, thank you all. We have a little bit of time left. We're running up against the hour, but I wanted to get to the last question that we had from our audience, which is from Colby, who wants to know about if you're going to go to a big firm directly out of school, what's the most helpful way to get involved in civil rights, public interest law, and a pro bono capacity? And I wonder if I could turn that to each of you to quickly, given our time limitations, hazard an answer at that. And how about we start with Kashana, if you have one, and if not, we can.
Sure. Yeah. So again, as someone who did not work at a big firm, but have definitely worked with people who have been at big firms, and field applications sometimes from those folks. For me, and I would guess for maybe many nonprofits that are doing civil rights work, what we really want to see is a demonstrated commitment to the issues that we work on. Right. That is what is first and foremost important to me in making hiring decisions. And I'm really open about what that, dedicated and demonstrated commitment looks like. If it is, a long history as a volunteer or activism while, working in big law, or if it's an AmeriCorps fellowship before, the law firm job, whatever it looks like, whatever you can point to that shows that you are committed to the cause or the issue and the community that you want to work within, as long as you can do that, as long as you can point to that, then I think that you can really do anything during your time with big law and then be able to make the transition into civil rights work. That would be my perspective.
Thanks, Kashana. Liz, for someone who wanted to, to go into big law, but then keep their options open and maybe pursue a future in representing government entities and defense, what kind of advice might you have for them?
So I think if you've already committed to a big law firm, sometimes it feels like your options are limited, especially when you're kind of bogged down with all these billable hour requirements. So if I were a new lawyer going into a big law firm and I had an interest in civil rights work, what I might try to do is see if the firm has a civil rights practice group and try to hit into them, or at least volunteer to help out on some of their cases. I might also explore the possibility of whether the firm has a pro bono partner, or, sometimes that's like a almost retired partner that kind of takes on public interest work. And so you can try to work on those cases. When I was a new lawyer, if my part of in the Northern District of Illinois, where Chicago is our federal district, if you're a member of the trial bar, you can get assigned to represent pro se litigants, pro se prisoners and things like that. When I was a new lawyer, my partners would get assigned to those cases, and then I would have to do the work. So I would file an appearance, and so I would be representing pro se prisoners in their litigation. So that was another good way to get experience. So that might be something you can explore if you're in big law already.
That's an excellent point on pro se representation. Thank you. Jonathan, do you have anything to add on that question?
As I understood the question, it was about what is the most effective way to get involved as a big law firm. And one of the things that, it's not going to probably be in your direct control early on, but I think one of the most effective ways that big firms can become involved is by basically filling in the weakness of the nonprofits with their strength. And pretty much any time you try to bring a big case as a nonprofit, a big law firm on the other side will try to do the stereotypical big firm tactics of bury you in motion practice, do giant document dumps, and basically, try to create a billable hour hell for the nonprofit on the other side. And I think one of the big things that you can do is push your organization to not be afraid of big cases, and to also not be afraid of the hard work of just assisting a civil rights tiny nonprofit with the giant pile of work that sometimes comes with a big case. And sometimes it's unglamorous document review, but if it's on the right side, that unglamorous document review can be a giant difference. So don't feel like just because it's a pro bono case and you're like reviewing a medical record for the 80 millionth time that you're not on the team, because fighting against a big law firm, which you often do in your biggest cases, requires that kind of resource sometimes. And if you can be that for somebody, know that you are helping.
All right. And Wiley, big finish.
Thanks. I'd say, there's the National Lawyers Guild right now is doing a tremendous amount of work out in the streets, right? You can be a legal observer with them. You can get trained. I know I'm doing a training next month. I know Skadden has dedicated a bunch of lawyers through the Bronx Defenders, and I'm going to help train them on notice of claims and defending 50H type depositions here in New York. So there are organizations like that out there. But I would say the National Lawyers Guild is a really good one to just look up the local chapter and just find out, what can I do to help? How can I jump in? And they'll have legal observer trainings. There's going to be more protests in the next 4 months than we probably had in the last 10 years. And so I definitely anticipate needs for this. If you're a law student, a young lawyer, looking to be active and doing things outside of big law, get a legal observer training in, put on the lime green hat, and come help.
Excellent advice, one and all. I did a terrible job of managing our time, and so there are many more questions that I had hoped to ask all of our panelists that we're not going to get to, but I want to thank them for sharing their time with us and their perspectives. I learned a lot that I didn't know already, and so I hope our attendees learned as much. And with that, and my heartfelt thanks to our panelists, I'm going to turn it back to Laura.
Thanks, Eric, and thank you to all of our panelists. This was great and really informative. To our attendees, thank you for participating. The next program is up on the screen. Please join us for that, and feel free to visit our Law Student Division webpage, where you will see many more programs being listed as we slot them. Don't forget to complete the survey on your screen. We really rely on your feedback as students to improve future law student webinar programming. And with that, happy Friday, everyone, and enjoy your weekend. Thank you.